I am curious though, if you had to pick whether this case is going to settle or go the distance, where are you leaning to? And is there any specific thing that could happen that we're waiting on that would really influence your decision one way or the other?
To reiterate, before Judge Torres on her own, I saw your one of the last videos you did. It's sua sponte is the Latin word that Jeremy was talking about. It's Latin for the judge can do whatever they want on their own. Usually judges can only do things that the parties ask them or that's in the pleadings, but there are some things they can do sua sponte, like completely on their own, and scheduling is one of them.
I'm still not going to
Before
say it.
before that came out, I thought, because remember, the summary judgment and expert witness briefing was the same. And so everything was the same and was on the same timeline proposed by the parties. And I just thought 80% chance this case goes all the way to the judge making a determination on that. I've recalibrated since that new scheduling order came out to saying, hey, this is a 50-50 chance of a settlement before the summary judgment is decided. And I say that because even though I think the SEC has gone too deep and has screwed themselves over too hard to kind of just back out now, because Ripple has a lot of the cards, I think it can still get worse for the SEC now before summary judgment, that they can be like, okay, let's use whatever last bit of leverage we have to get something out of this, before we're completely, get our butts handed to us. And that's the expert witness decision. So if that comes out, well, let me backtrack a little bit. So originally it was on the same briefing schedule, expert witness motions. We also call those Daubert motions in the legal world from a case
So when
called
you say on the
Daubert.
same schedule, can you just break that down real quick? Because I read your tweet thread and I saw that the expert witnessing getting moved up changed your opinion significantly, but I couldn't quite comprehend why that was the case.
Sure, without getting too legalese, you have to think about all the different types of motions that are filed in a lawsuit. We already saw motions to dismiss, that's over with. We're doing motions for summary judgment, which means, hey, we're going to agree on all these facts, or the parties won't agree on all the facts, but they'll put evidence to the court saying, Judge, you can't listen to the other side. Here's the facts. Here's what the document says. Here's what the witness testified to. And based on those facts, which a jury can't contest, the law is clear that the result should be X. Mm-hmm. And so that's summary judgment. Now, after summary judgment, if the case is still going on, there'll be another type of motion saying motions in limine, which basically means we want you, Judge, to eliminate this evidence from being shown to the jury. We got this evidence in discovery, but it can't be admitted for a lot of reasons at trial. Again, you don't have to worry about motions in limine yet because we're not there. We're at summary judgment. Another type of motion is what's called, it's like a motion in limine, but it's very specific to expert witnesses. And we call them Daubert motions, D-A-U-B-E-R-T, because it's a very famous case that talks about what expert witnesses can and cannot say. What are they qualified to say? What are they qualified to say in general? And what are they qualified to say based on the facts of the case? And so those come before the other motions because they're hugely critical, because expert witnesses, when there's a case that requires an expert witness, the expert witness is absolutely critical. When I do my medical malpractice cases, I have to have an expert nurse or physician that says, hey, the defendant nurse did X. What the standard of care requires is that they did Y. And this is why, because of my nurse background, this is what you're supposed to do. And this is why the defendant nurse failed. And that's what Ripple's experts are doing. That's what SEC's experts are doing. They're saying, hey, in the securities context, you would have to do X. Ripple's experts are saying you have to do X, Y, and Z with securities. These aren't securities for this reason, based on my expert opinion. So that's going to be a huge factor at a trial if it goes to trial. And so what the expert witness motions do, the Daubert motions, it says, okay, Ripple's going to say, hey, the SEC's witness is vastly unqualified for these reasons, or they may be qualified, but they cannot credibly speak to these issues in particular, for a variety of reasons. And because that was originally proposed by the parties, those expert witness Daubert motions to be on the same schedule as summary judgment, there wasn't going to be that leverage, in my opinion, to force a settlement before summary judgment. But Judge Torres rocketed up that deadline. And I mean, that is so condensed. I think like it's a month, they start filing them. I can't remember off the top of my head, but I think the replies are due basically at the end of August. I mean, that's going to be a billing bonanza for the attorneys for Ripple. I mean, that could be like $5 million that month right there.
Wow.
But what that tells me is that the judge is saying, I'm staging this, so you're going to have more chances to settle. And that's what I'm really hoping is going on behind the scenes. So, I mean, again, you got to read the motivations of the judges and everything. The Judge Torres really wants the parties to settle because she knows this is a momentous case and she'd like them to figure it out on their own. I don't think she's afraid at all to make an opinion, but when the government is in this situation, she's kind of basically saying like, you guys should really figure out a way to make this work out for both of you, to compromise. And so by putting that Daubert motion briefing so far in advance, I don't see, she could take a long time. And James Filan, he speculated that he thinks they're going to be decided at the same time. I think that's what he said in his last tweet storm, but I think they're not. I think one of the reasons she did vastly put that schedule up is because she's going to decide that before summary judgment is done with, because it works both ways. I think Ripple's going to come out on top, but if the SEC's experts are significantly reduced or limited or stricken altogether, and or the SEC loses their motions against Ripple's experts to say, hey, they can't talk about X, Y, and Z, I mean, that's really going to change the calculus for the SEC, and that could deal a crippling blow to them for what actually matters, or the biggest thing that matters in this case is XRP a security. So if that comes out in September, October-ish, the ruling on the experts, the SEC could be like, oh my gosh, we are 100% totally screwed. Like, we got to try and settle to get something, or we're going to get nothing.
Mm-hmm. So you made me laugh. I was just thinking about who the SEC's experts are. Knowing the SEC, they're probably going to walk in with like Joseph Lubin and be like, oh, here's our expert.
Well, I, before I got a little more people that were interested in what I was putting on Twitter, a couple of my older tweets, maybe if you go back and search like expert witness or something, they've revealed some of their experts in various pleadings and in various exhibits. I've gone through it. So I figured out about 5 or 6 experts for Ripple that they have, and I've got about 2 or 3 from the SEC. And what's hilarious about the SEC's experts is it's either 2 or 3, but all of them, I went and I looked back. These are the SEC's go-to experts for everything. So what Ripple is going to do, even if they don't get stricken, at trial, they're going to be like, well, how often have you, because Ripple's experts are all going to say, we've only done this with Ripple once, or, this is the first time we're working with Ripple. All of the SEC's experts have to say, we've got a 5-10-year relationship with the SEC. We've worked on, 120 cases with the SEC before.
They're just going to be like, we say whatever they want us to say.
Yeah. And so, what juries usually do is, they kind of say, okay, well, experts are hired guns, but then it goes to credibility. If the jury crosses the threshold of saying, wow, this is your go-to expert that will say anything that you pay them to say, we're not going to listen to them. And so again, that's way down the road at a jury, but the thing is that their experts are weak. I haven't read their expert reports, but they are. We know a little bit about one of them because there's the supplemental finding from Metz, but I even looked at his report, and he was using lawyers, and experts aren't the greatest with like images and JPEGs and stuff, but like, I mean, it was basically, even the font in that guy's report is when you pull open Word, Microsoft Word, it's like the automatic font that it gives you. It's the automatic Roman numeral headings that it gives you. You know, everything was like as basic as it comes. And, you know, it was just like, all right, what do I got to do to make this fit? I mean, he had like the marble jar gift that was just ridiculously, it just didn't fit the complexity of the case, basically. So, you know, it's just it's a say anything expert, and you know, when that gets clarified as to who can say what, then you know the SEC is just like, we got to get something out of this. And I think that's when they're like, all right, okay, fine, let's settle. We can settle, because I think even with no leverage at all, they can still get $1 billion, maybe even 2 billion, like you said. I mean, especially if they're like, just give us 1 billion XRP, and it goes to $5. I mean, all of a sudden they got $5 billion. So it's, you know, they'll get the money. It's just they have to be beaten over the head to a point where it's like, okay, we got to get out of this.
Yeah, well, I think that's kind of the interesting thing I was getting at before. It's like the SEC, even though this could very well be seen as an attack against Ripple, their payday gets better with how high XRP goes. So they're almost incentivized to make XRP go up more, because then they get a bigger payday. They could ask for who knows how much money. And I'm sure Ripple's willing to put a lot of money on the table at this point just to get this thing over with. But I definitely think that's pretty interesting. Do you think, like, it's kind of hard for me to see how the SEC could possibly come out at this point and say XRP is not a security? For me, it seems more like we don't see XRP as a security. Is that a distinction the judge would have to make? I just have a hard time. I easily see how the judge can say, all right, Ripple didn't know, whatever. The SEC can't say that Ripple knew this entire time that they were selling securities. But where does the actual decision on the status of XRP come from? Where do you think that's most likely?
Well, you know, if it goes all the way to summary judgment, then the judge will make a determination, or, you know, she'll punt and say, you know, the jury has to make this determination. And then, I mean, can you imagine just getting 12 random people in New York to sit through this trial? Will be like 2 months, 3 months long. And, you know, the jury's just going to be like, I mean, I've had 2-week, 3-week trials, you know, over simple things. And, you know, you look over and, you know, juror number 4 and 8 are like,
that must be so scary. You're probably sitting there like,
yeah. And, you know, I tell this story to my clients all the time. I had one case where a partner in a firm I used to work at, the jury went out on a Friday to deliberate, and then they came back at the very end and said not liable. And then another juror 3 months later, so they lost the case, and everyone was blown away because we turned down a high settlement offer, because another juror came back 3 months later, called our office and was like, I feel terrible about this, but we were going to fine for your client. But then this one juror got up and said, damn it, I've got a vacation starting on Monday and I am not going to miss that vacation. So we're just going to say not liable. And they bullied the other people to come up with a not liable finding. And, you know, you can't do anything about that.
That's crazy. I have a really hard time thinking that Judge Torres would put this to a trial by jury. I could see the Brad Garlinghouse and Chris Larson case getting there because it's a little easier to wrap your head around. But I mean, whether or not XRP is a security, I was shocked with how well the judges were able to comprehend what cryptocurrencies even were. I mean, that normally takes people 6 months to a year just to wrap their head around that. So the fact that they were coming out swinging just on their technical knowledge, I was pretty impressed with. It's really hard for me to believe that they would waste all this knowledge they've accumulated on the status of XRP and then say, like you said, oh, here's some random people, go get familiar with what a cryptocurrency is, decentralization, Ethereum, XRP, and say, all right, decide on this critical issue for all of crypto. That for me seems like it probably wouldn't happen, just because the judges, I've been so impressed by the judge's knowledge of what's going on. It seems like it makes a lot more sense for them to make this decision. If the case did get settled, do you think the parties would need a statement by the judge saying, this case, XRP is not a security going forward, or would that come from the SEC, do you think?
So it depends on what happens. The first thing would be, to finish the question that you asked, is I think a summary. I do think the Judge Torres would decide it on summary judgment, and I think she could split the baby by saying, based on case law and the facts, XRP actually was a security right up until X date. And then after that, it's sufficiently decentralized to not be a security anymore. So she could split the baby that way. And that's still great for XRP holders because now it's no longer security going forward. And you get some regulatory clarity. On the settlement side, it would be like a decree, or it would be a public settlement agreement where the two parties would put together a document that says this is what we agree on, and then the judge signs off on it. So it's an order that the judge blesses. And the judge could look at it and say, I don't agree with this at all. We're continuing down the summary judgment path, or the judge could sign off on it. And again, it could say the same thing. So that's, again, if the SEC is really beaten down, they could say, Ripple's attorneys could be like, you're not going to win at all on anything. And, they could say, we want you to admit it was a security up till 2016. And Ripple, for rightly so, could say, no, it definitely wasn't. It never was. But at the same time, the SEC could say, all right, well, then we're going all the way to summary judgment. And Ripple could be like, fine, we'll agree. It was a security through 2016. It's not anymore. That's got to be very specific. We pay, this amount of money, and then boom, you still get the XRP is not a security. The parties in the settlement, quote unquote, agreed, but the judge also, quote, determines it's not by adopting the parties' settlement terms. And that's how you could resolve it there.
Yeah, no, that's interesting because I was having a hard time wrapping my head around exactly how that would work, but that seems like makes a lot of sense. And I think it also says a lot about, this is not going to be an easy thing to settle in terms of they can just get together and be like, all right, let's settle this thing, because it's clearly going to take some very specific verbiage on what XRP is going forward. And I think we both agree that that's going to define almost the status of pretty much every single cryptocurrency going forward.